Okay, everybody. This is part two of the complaint from the Securities and Exchange Commission versus Georgios Palikaras and John Brda. It's number 004806 this year. I think it's a complete frivolous complaint as I read it, but I'm not an attorney. I just did about an hour and a half on it earlier, and I was worked up because it just shocks decency and integrity and honesty. This guy has to work his way. The two attorneys, Patrick Dis-Bennett and Christopher Rogers, they have to work themselves into pretzels to make any logic on this case. It's not a case, it's a frivolous case. It's completely frivolous. But I'll try to be less worked up and get through the remainder with fewer asides. So starting at page 11 where I left off, they had been accusing Brda of intending to cause a short squeeze because of the difficulty he believed short sellers would have in obtaining and delivering the preferred dividend. Well, okay, what's your side of that particular issue? If the SEC is so keen on disproving this belief, show us the data. Then number 32, by at least June 2020, Brda had conceived of and began planning the preferred dividend with the intent of causing a short squeeze. Well, that might have happened, but he's also trying to protect his investors and monetize an asset, which is the shell company Torchlight. In June 2020, for example, he wrote to the chairman of Torchlight boards of directors and its primary banker, by issuing a preferred to Torchlight shareholders of record at closing and announcing it as part of a merger agreement, the short position, which is quite extensive, will be forced to cover. Well, that's opinion, and it's a valid opinion. The short position took well over a decade to create, and it's an imbalance between supply and demand because the SEC simply does not enforce security laws at all, particularly as it relates to settlement, if they violate the best interests of Goldman Sachs, etc. They just don't. So who can blame the CEO of taking into his calculation the fact of what we now believe could be 2 billion shares that are fake? Which means stolen from the markets. It's not a white-collar crime. In September 2020, Brda proposed the preferred dividend to Meta One and secured Meta One's initial consent via letter of intent that Torchlight and Meta announced on September 21, 2020. He subsequently negotiated and secured Meta's consent via a definitive agreement, which included the preferred dividend, which both companies announced on December 14, 2020. So what's wrong with that? Brda also caused Torchlight to propose and solicit shareholder approval for his intended structure of the preferred dividend. What's wrong with that? I mean, what acquiring company is going to want a scraggly ass oil and gas company? They're not going to want it. This includes, but is not limited to, shareholder approval that Brda solicited. Okay, you'd rather he didn't? Via Torchlight's definitive proxy statement. You don't want him to file a proxy statement? Dated May 7, 2021, which Brda approved. What's wrong here? Attorney disinterested, and Torchlight's preliminary proxy statements, which Brda approved on 3 dates. Palikaris, as CEO of Meta One, shared Torchlight's proposed merger structure, including the plan to use the preferred dividends to impact short sellers, to have an impact on. Only your molars are impacted. To have an impact on short sellers with Meta One's board. In Brda's initial presentation to the board of directors on 2020, which Palikaris knew about and helped convey to his board, Brda presented his plan to emphasize the preferred dividend by using merger announcement press releases to, quote, play up the preferred share dividend to make sure the shorts understand their dilemma, unquote. Only a criminal attorney who is representing criminals like you, Attorney Patrick Dis-Bennett, would even come up with this logic. What is wrong with a CEO or a group of investors realizing that what goes down must come up, in the sense of the criminals are pushing on a rubber band, stretching it out, and eventually they've got to cover their malfeasance. But you don't care about that. Just cash your checks. Cash your checks this coming Friday. Make sure that you can pay your club dues. Don't have any conscience at all. In Palikaris' sworn testimony given during the SEC investigation that preceded the filing of this lawsuit, oh, brilliant. Man, you really got him. Palikaris, how old are you? Palikaris admitted that Brda explained to him, quote, way back in the beginning that this deal could potentially create a short squeeze. No effing. No kidding. So, your clients, the SEC protects, that's where the money's flowing, to buy out Gary Gensler, I'm sure. By the way, again, on this video, like the last one, all my opinion, all my judgment, everything is on evidence and belief. If I somehow get it wrong, I apologize. But dude, you need to go back to law school. Or you need to get into a field where you can be proud at night to lay your head down and say, gosh, I did a good thing today. This is bad thing. So what's wrong with saying it potentially could create a short squeeze? That's really thin beer. You're going to be laughed out of court, Mr. Dis-Bennett. Meta One's board also communicated with Palikaris about Brda's plan in a September 6, 2020 email. A member of Meta One's board wrote the other members, including Palikaris, to summarize the proposed deal based on calls with Torchlight management, including Brda. In that email, the Meta One board member wrote that a goal of merger structure was to, quote, raise enough money when the shorts get squeezed to delimit all short Torchlight's debt, unquote. Hey, pal, disinterested? Do you know that your criminal class, the SEC's protected criminal class, just organized that exact same thing over the last 3 years with AMC. You can look it up. That's the symbol, AMC, and GME. Same thing, only the criminal class coordinated it, so you're not going to go after it. In this case, you're trying to create a crime out of a CEO and two CEOs trying to do the best thing they can out in the open, by the way, out in the open with full disclosure and SEC filings to improve shareholder value for all shareholders. I can't believe I'm reading this sitting here for free and you're getting paid for writing this crap. So what? This could potentially create a short squeeze. That's what you're putting the weight of this on? Your career is going to be blessedly short. Meta One's board also communicated with Palicaros about Brda's plan. In a September 6, 2020 email, a member of, and of course you don't go after the criminals because they use WhatsApp and other things. They have sophisticated ways of getting around your surveillance, but you don't look. You don't look. In a September 6, 2020 email, a member of Meta One's board wrote the other members of Meta One's board, including Palicaros, to summarize the proposed deal based on calls with Torchlight management, including Brda. In that email, the Meta board member wrote that a goal of the merger structure was to, quote, raise enough money when the shorts get squeezed to eliminate all Torchlight's debt, unquote. Obviously, he's predicting the future. He doesn't know what's going to happen, unlike your protected criminal class that employs your boss. They know what's going to happen. They've done it thousands of times with your help. He wrote that Torchlight, quote, currently has in place and approved an at-the-market offering, and that Torchlight's plan is to either use the ATM or do a deal with a brokerage firm they have a relationship with to raise capital in the event of a short squeeze and or inflation in Torchlight's stock. Pal, the reason the stock was deflated is the SEC protected criminal class. The actions of the SEC's protected criminal class. Thus, at the outset of discussions between Torchlight and Meta, this is not only a really crap lawsuit, it's just so boring to read. I guess you're doing it so you can eventually be a partner at Gibson Dunn or some other firm like that. If I were the senior partner somewhere, I would never hire you. Thus, at the outset of discussions between Torchlight and Meta One, Palicaros knew about Brda's plan and intent. Yeah, to do something as best he could in the face of the SEC's protected criminal class's actions against his shareholders. Palicaros actively worked with Brda to carry out this plan to manipulate the price of Torchlight stock and defraud Torchlight investors. Wait a minute. They're going to get the stock to go up and they're going to raise money on behalf of investors. How does that defraud the investors? Who defrauded the Torchlight investors was the SEC's protected criminal class. But you don't care about that. Brda and Torchlight made several public disclosures about the preferred dividend, but those disclosures were misleading and in some cases false, much like this lawsuit. mean, you could be describing your own writing because Brda omitted material information, as does the SEC, the blue sheets, about the plan to use the preferred dividend to manipulate the price of Torchlight stock and defraud investors. You don't have foundation in here that that was the sole plan. That was something that might happen. And if it's a strategy to catch out the shorts, trap the shorts, why not? The counterfeiters, the SEC's protected criminal class, had been destroying the stock for over a decade. This is a weak-ass lawsuit, pal. Brda had ultimate authority to approve Torchlight's May 7, 2021 definitive proxy statement and its preliminary proxy statements dated 4th, 23, Feb 4, 23 March, 21 April of the same year. Pursuant to that authority, Brda approved Torchlight's definitive and preliminary proxy statements. Okay, which gives disclosure. Unlike your employer, they don't disclose F-all. He also signed the cover letter to Torchlight's proxy statement. In those proxy statements, Brda and Torchlight solicited, shareholder approval for the merger and preferred dividend. Brda and Torchlight publicly disclosed in these proxy statements, among other things, the terms of the purported reasons for and the risks associated with the merger. Okay, they discussed the terms, the reasons, and the risks. What's your issue? Are you just out of law school? Certain of these disclosures, however, were false and misleading, like your whole case. But I guess consistency isn't the job of an attorney. Because Brda knowingly or severely recklessly failed to disclose material information to investors. That's pretty powerful. What did he fail? Next sentence. Specifically, Brda failed to disclose and failed to cause Torchlight to disclose the following. 1, that the preferred dividend was intended to cause and lead investors to believe that there would be a short squeeze and increase Torchlight stock price. That's your opinion. There's no evidence. You showed there was a discussion that it could, but there's no evidence that this is why they created a preferred dividend. The most likely reason, as stated before, is Meta Materials, as an applied material company, had no interest in owning an early stage oil and gas company. You were the one who's writing misleading charges and omitting information. Two, that Brda believed the preferred dividend would cause a short squeeze and or temporarily inflate Torchlight's stock price. So now you're going after beliefs and thoughts? Yeah, a lot of us thought that. And you know what, pal? Mr. Distemper, Attorney Distemper, there's evidence the stock traded at $2,400 a share. Truth is a defense. That the potential for a short squeeze and or temporary inflation of Torchlight stock price were reasons that Brda and Torchlight considered in approving the merger. So now you're saying that the recommendation and the recommendation of approval of this merger and the preferred dividend was that there was a potential for a short squeeze. And how do you know that temporary inflation in a stock price How do you know? Be temporary. You know, there's something about the stock markets, they fluctuate. There's something about your career, it's going straight down. Four, Brda's plan to and or the potential that Torchlight would deploy the ATM offering. And five, that in connection with negotiations over the merger and preferred dividend, Torchlight and Meta One discussed the preferred dividend's potential to cause a short squeeze. Only an idiot like you couldn't see that potential. Its potential to temporarily inflate Torchlight stock price. No, I don't think they have any illusion that the SEC protected criminal class has an ongoing ability to deflate share prices. So I think they felt anytime the stock price went up, in would come the SEC's protected criminal class selling counterfeit shares, deflating the stock price. So any rally would be a good time to raise money, huh? And then fight the SEC's protected criminal class. And they says here he didn't disclose the plan to use the ATM offering to raise funds from investors. Well, I don't think you've gotten enough foundation in there to say, it's not clear at all that he didn't disclose that and that he didn't discuss it, or that that was locked down at that time. It's irrelevant anyway. To illustrate my puny point, Torchlight's definitive proxy statement described the purported reasons and factors that Torchlight's board, including Brda, considered in approving the merger and the dividend and recommending the shareholders approve the same. Do you get paid by the word? The proxy statement repeatedly states that the supposed reason for approving and proposing the preferred dividend is that it quote, provides the current Torchlight stockholders an opportunity to retain their beneficial interest in Torchlight's oil and gas assets, unquote. Yeah. Why not? They invested it for that reason in the first place. Oh, this is nefarious, Attorney Distemper. This is nefarious. These statements were false or at least misleading, in your opinion, because you're a knucklehead, because Brda and Torchlight failed to disclose in the proxy statement and the subsequent public filings that the reason, or at least a reason, that Torchlight and Brda considered was Brda's plan and intention for the preferred dividend to cause a short squeeze and or temporarily increase Torchlight stock price. Look, Brda had experience with the SEC's protected criminal class long enough to know that anytime the stock price went up, the criminals you represent were going to drive it down via the SEC. In terms of the intention, this is not why they issued, you just got it wrong. You're just wrong. The reason for issuing the preferred dividend is to get an oil and gas asset off of a publicly traded applied metals materials company's balance sheet. That's it. 42. Similarly, Torchlight's definitive proxy statement also stated the anticipated and intended impact of the preferred dividend is to maintain the interest of Torchlight stockholders as of the preferred dividend record date in Torchlight's oil and gas assets. What is wrong with this? After the consummation of the merger. Again, this statement was false, or at least as misleading as my own words are, because Brda and Torchlight failed to disclose in the proxy statement that an anticipated and intended impact of the preferred dividend was that it would cause a short squeeze and or Look, you can keep repeating it. It's a weak-ass argument. Brda also failed to disclose that he and Torchlight planned to conduct an ATM offering. So, on the one hand, he's telling people they're going to use the preferred dividend to either cause a short squeeze or temporarily, they're saying temporarily, increase Torchlight stock. But then he didn't tell everybody, this company who's in dire need of capital, that he planned to do an offering to take advantage of higher prices. Did you vote for Biden? Contrary to Brda's and Torchlight's representations that the preferred dividend was intended to protect the interests of Torchlight legacy shareholders. Here comes the argument. There comes the argument. The ATM offering that they were planning in coordination with the preferred dividend, which they failed to publicly disclose, would actually dilute those legacy shareholders' interest by injecting new off-the-shelf shares into the market. You are a bloody fool. You don't understand the markets. You're just trying to create a sin here so you can make some money. I'm just going to move on, because if I go into explaining that, it'll take 5 minutes. Torchlight's definitive proxy statement was also incorporated by reference in certain public filings that were considered to be part of this proxy statement, including its 2020 Form 10-K, filed in March of 21. Brda signed it. In that 10-K, Torchlight disclosed, quote, "The market price of our common stock may be influenced by many factors, including, among many other factors, actual purported short squeeze trading activity." So they disclosed it. But now listen to this absolutely puny attorney's further argument. However, this generic disclosure made no reference to the preferred dividend or the intent or potential for the preferred dividend. See, what I think Brda said is potential. This guy is adding in intent. This is a misleading attorney. To the preferred dividend or the intent or potential for the preferred dividend to cause a short squeeze. So they disclosed it, but they didn't specifically mention, apparently, the preferred dividend. Maybe it's because they weren't sure that that's how the interests were going to be distributed. Similarly, Torchlight's definitive proxy statement disclosed several risks. Oh my gosh, they disclosed risks, including the proposed preferred dividend. At a minimum, these generic risk disclosures were misleading because Brda and Torchlight never disclosed in those filings or subsequent filings the risk that the preferred dividend could cause a short squeeze or artificial price increase, much less that the preferred dividend was intended to cause the same. See how he keeps putting his opinion in over and over again? Nor did Torchlight or Brda disclose their intention to conduct an ATM offering. This guy's an ambulance chaser. This is one of the worst attorneys I've ever read an argument of. Torchlight 2020 Form 10-K further represented to investors that we have no reason to believe our shares would be the target of a short squeeze. So on the one hand, they're saying the risks of it. Then they're saying we have no reason to believe. What the hell are you on about? Attorney disinterested. As Brda knew at that time, however, that statement was false, as it was directly contrary to his and other executives' privately stated belief. Come on, pal. Come on. Private discussions about to predict the market are different than having knowledge that a short squeeze is going to happen. The SEC should fire your ass immediately. I think your job, you'd be better running a restaurant somewhere, preferably one that just shut down 50 stores. So the directly contrary to his and other executives' privately stated belief and intention. He throws in intention. They don't control it. It's the protected criminal class of the SEC's side that controls these things. In fact, a note taker at an investor conference on March 17, 21, the day before Torchlight filed its 10-K, the note taker recorded Brda telling its investment firm, quote, 15 things driving our stock price. Last thing before closing is a short position. It's hard to deliver dividend if short on closing. He's just stating the facts. At a minimum, the representation was misleading because Brda admitted from the 10-K and other filings that he and other executives believed the preferred dividend would cause the short squeeze or temporary increase in Torchlight's stock and the plan to use an ATM. Look, you can keep repeating it, but you ain't no genius. The definitive proxy statement also purported to detail the discussions and negotiations between Meta One and Torchlight concerning the merger and preferred dividend, along with each company's purported motivations and reasons for the transactions. For example, the proxy statement stated that Meta One, quote, suggested that the parties structure the transaction so that all of the value of Torchlight's oil and gas assets would be allocated to legacy Torchlight stockholders, unquote. Of course, why would a technology firm inventing the next generation of green energy and other technologies, why would they want an oil and gas company? What's the sin? Other than having to read your drivel. Torchlight, what I just read, Torchlight purportedly found attractive and beneficial to its legacy shareholders. As Brda knew at the time, however, these statements and disclosures of Torchlight and Meta One's negotiations were misleading. In the proxy statements and subsequent public filings, Brda and Torchlight never disclosed that they had proposed the idea of a preferred dividend. I have to keep reading his allegation as if it'll make it true. That they intended to cause a short squeeze and or artificial increase in Torchlight's stock price. If I keep reading it, it'll suddenly be true. The SEC's protected criminal class caused an artificial, prolonged depression in the share price of Torchlight and fraudulently made it impossible for Torchlight to capitalize itself and therefore show growth in its oil and gas assets. In fact, Brda and Torchlight never disclosed. They're just going to keep repeating the same thing. In the proxy statement or other filings that the short squeeze was even discussed during these negotiations, because it's speculation. Nobody knows for sure if a short squeeze is going to happen. But you try, as a CEO, fighting the SEC's protected criminal class, you try anything to make the reconciliation of the trades that the SEC so assiduously ignores. In addition, the September 6, 2020 email from Meta's board member reveals that during negotiations, the two companies discussed Brda's short squeeze theory, Torchlight management belief that Torchlight stock would increase, following the announcement of preferred dividend, and the ATM offering that Torchlight had available and planned to use to take advantage of a squeeze or price inflation. Now, you know what, guys? We should announce these things, but let's not do an offering until the SEC's protected criminal class has finished, let's say over the next 6, 7, 8 weeks, the additional selling of further counterfeit shares. So let's let the stock rise. Instead of Torchlight taking advantage of higher prices to capitalize their own company, let's let the criminals, the counterfeiters, take that money, because the SEC protects them. That way the money, investors' money, will go over to the counterfeiters and the offshore purloiners and to the SEC's overseers at Citadel, Goldman Sachs, and or the rest. So let's let the criminals take that money. If the CEO decides when his stock price is up to tap the capital markets, we better go after him. That's fraud. The other fraud to trillions of dollars, let's ignore it. It helps Goldman Sachs. The big man upstairs came from Goldman Sachs. Let's just ignore that. And besides, if Distemper and Ginger Rogers want to get a job at Baker Hostetler or wherever, this will help. In furtherance of the fraudulent scheme, however, Palikaros never disclosed private communications. This is so boring. I'm just going to skip over the exact. He just repeats everything over and over. But now he shifts his opinion to make it factual. Defendants' communication suggests their intentions and motivations in refusing to publicly disclose the planned short squeeze. They couldn't control the short squeeze. They're talking about it. It's only the SEC's protected criminal class that has any say in a short squeeze. There was a I forgot what I was going to say. Anyway, this is trying to just keep, by repeating it, you hope the judge believes what you're saying. It wasn't planned. If it happened, they would take advantage of it. They planned for it. Planning for it is different than planning it. Only the criminal class is able to suppress prices over and over. Only they control the markets right now, except in rare cases. And that's why they hired you, to stop this one rare case. Oh, now he's going to quote an anonymous StockTwits user. Boy, that's some good research. June 7/21, King One Foal posted that, quote, the Italian investor call, which is discussed below. King O'Foal posted a screenshot from a recording of the call and a synopsis of 4 takeaways from Caloranis's private statements on the call. So somebody else's notes? Unbelievable. That's not hearsay? Including the idea that Torchlight's announcement of the preferred dividend record date would, quote, create a short squeeze as there are many short stocks to cover before the merger. Yes, and truth is a defense. Look at what happened in trading. Reports are, in a lawsuit filed, that there were trades at $2,400 a share. $2,400 a share. That's a short squeeze by any measure. Within 3 minutes of the StockTwits post, Palikaros emailed a screenshot to Brda and other members of Meta One's management, angrily demanding that investor relations personnel contact King One Foal and insist that the post and recording be deleted. And you're upset with him? You're the worst attorney I've ever seen. Palikaros confided his concern to the CFO that the deal would, quote unquote, blow up if his private communications about the squeeze became public. Furtherance. Defendants deceptively marketed and promoted the preferred dividend in furtherance of the fraudulent scheme. In addition to concealing their scheme from the market through misstatements and omissions, doesn't seem that way. They didn't want, doesn't seem that way at all. Defendants deceptively marketed and promoted the narrative that the dividend would cause a short squeeze in furtherance of their plan to artificially inflate. Why is a higher price artificial inflation, in your opinion? Who died and made you God? As further described below, defendants took steps to market and promote the preferred dividend in ways which were intended to, 1, cause short sellers, in the words of Brda, to understand their dilemma. What's wrong with that? Only someone blind like yourself wouldn't take into consideration all facts and the level of the playing field, the lay of the land. I mean, come on. To understand their dilemma. I see. Where Brda sees a dilemma, you see the ability of the SEC to control, put the SEC's massive paw on the scale of supply and continue to allow the protected criminal class to suppress the price artificially. I see. So there is no dilemma, right? So Brda's words were to understand their dilemma, unquote, and therefore trigger a short squeeze. And two, increase interest and confidence among legacy and prospective Torchlight shareholders, as well as convertible promissory note holders in anticipation of a potential short squeeze. You know what, guys? If you're a CEO listening to me and you need capital, do not list in the US markets. Do not list on the over-the-counter markets. Do not list on the NASDAQ markets. Do not put yourself on the supervision of the SEC. Just don't do it. Stay private. Initially, defendants believed that they could simply, quote, play up the preferred dividend in press releases to trigger a short squeeze. From what I read, it sounds like they thought it might. It might, but they don't know. Remember, it's the SEC's protected criminal class that controlled the price in Torchlight, MMAT, and MMTLP. How? They just counterfeited shares on a scale that overwhelmed any buying interest with the SEC's acquiescence. In a written presentation to Palacaris and Meta One's board in 2020, Brda proposed his plan to emphasize the preferred dividend by using merger announcement press releases to, quote, play up the preferred share dividend to make sure the shorts understand their dilemma, unquote. So he's used the same quote 3 or 4, 5 times, if I remember. Doesn't change it. Doesn't change it. He's playing it up because they're caught. The SEC's protected criminal class was caught. There's nothing illegal about that. Likewise, in the September 6, 2020 email from a Meta One board member, the board member wrote to his fellows based on 2 separate calls, Torchlight's well thought out strategy is to finalize an LOI with Meta and strategically jointly announce it by way of a joint press release after the markets close. What else the hell is he supposed to do? This is really a pitiful lawsuit. The board member wrote the joint press release, quote, will announce that at the closing of the transaction, all current shareholders of Torchlight will be issued an equivalent number of preferred shares, unquote. So he also explained that per Brda's strategy, if the 2 companies agreed on, quote, when the joint press release goes out, the shorts will only have the weekend to come up with their own strategy to cover their short positions, unquote. Yeah. Yeah. What's your point? He added that, quote, Torchlight's management is confident that unquote, that, and now it's paraphrased, that Torchlight stock price would go up following a press release playing up the preferred dividend. Okay, he's taken that same quote, he's woven it into at least 2, maybe 3 pages of writing. It's bogus, but I guess he gets paid by the word. Consistent with this plan and proposal, Brda caused Torchlight to issue a press release announcing its merger, which Brda participated in drafting, and it was attached to Torchlight's September 23, 2020 Form 8, which Brda signed. The press release emphasized in the release's title, quote, special dividend intended to be issued to Torchlight shareholders at closing, unquote. Okay, so he announces it to everybody. What's wrong with that? That's full disclosure. Similarly, Torchlight's December 14 press release, which Brda participated in the drafting and was attached to Torchlight's December Form 8K that Brda signed, announced MetaOne and Torchlight's definitive agreement to merge and highlighted in its title, quote, preferred stock dividend to be issued to Torchlight's shareholders prior to closing, unquote. I'm skipping. I'm going to start skipping a little bit. Brda deceptively highlighted this one aspect of the merger transaction, the preferred dividend to be issued at closing, with the intent of causing shorts to exit their positions. Are you making up facts? I don't think there was anything deceptive about that. In fact, if you read the fact sheet from FINRA, December 12th, record date, 14th, distributed. 13th, trading symbol deleted. It's all there. Following the December 21, 2020 press release, the market did not appear to immediately react the way the defendants intended. Well, of course, the protected criminal class just always sells on any news, but that doesn't bother little Bill, did it? As a result, Brda turned out to some consultants he knew to spread the short squeeze narrative. Brda caused Torchlight to pay these consultants to communicate with current or potential Torchlight shareholders. Through these individuals, two of whom Brda introduced to Palacaras as guys on stock support, Brda communicated information about the preferred dividend and short squeeze to shareholders. I wonder who those guys on stock support are. Anyway, different subject. For example, September 21, 20, Brda forwarded to two consultants Torchlight's press release. Nothing illegal there. Announcing the merger and the dividend. As reflected in the exchange, Brda instructed the consultants, who he's paying for, how they should message the preferred dividend to investors. There's nothing wrong with that. Brda, we need you guys to embrace it. In my opinion, you get the Torchlight value to $1, and then 25% of Meta is free. Lots of room to build a nice position. Consultant agreed. Everyone I spoke to today love it and are buying more and are long-term investors. Tons of volume, but not moving up. Because the SEC's protected criminal class can sell into existence non-existing shares in volumes that will crush any buying. And that is protected by the SEC. Brda, I think people don't understand the dividend properly. Consultant, I agree. I'm explaining it, and I can hear the light come on while I'm talking to people. How do you hear a light come on? I leave that aside. In January 21, Brda emailed information about the outstanding short position in Torchlight to the stock support consultants. You know, the protected criminal class hire day traders to destroy stock price. They collude. They spread FUD. But you, attorney dissembler, you do not care about that. To further conceal his deceptive use of stock support consultants, Brda caused Torchlight to keep inadequate books and records to maintain inadequate accounting controls concerning these consultants. In January 21, Brda emailed information about the outstanding short position to the consultants and wrote, quote, "We all knew the shorts would come after us one more time. They are creating a massive bubble, in my opinion, that is going to slingshot in our favor. The dividend is going to be a huge problem for them." It's in his opinion. There's no question that the SEC's protected criminal class is shorting massive amounts of non-existent shares, which you don't care about. He's making a logical conclusion. You're probably confused by what a logical conclusion is. There's always time to pick another profession, attorney distemper. To further conceal his deceptive use, okay, that's the bad records, other than generic contracts obligating the consultants to, quote, introduce the company potential investors, Brda caused Torchlight to keep no records documenting why Torchlight paid the stock support consultants $3,000 to $5,000 per month plus stock warrants for their services. It's a nice gig if you could get it. Wall Street is paid massively, as are you, attorney distemper, to look the other way. Don't get all moral on that. Every bit of the money that you're getting on this case is coming from the protected criminal class purloining investors' monies in the very markets the SEC is sworn to protect. But you don't care. Brda and Palikaris also deceptively had direct communication with select groups of investors where they further played up the short squeeze in furtherance of their scheme. Man, I wish I'd gone to Harvard. I learned how to use the word furtherance. For example, from March 16 to 1821, Brda and Palikaris met with a series of institutional investors as part of an investment bank's virtual annual investor conference. During these meetings, Brda and Palikaris pitched the justification for the merger and described to at least one investment firm the potential for the dividend to cause a short squeeze. A note taker at the conference recorded Brda telling the firm, quote, 15 things driving our price. He's quoting the same damn thing he already quoted before. 15 things driving our stock price. Last thing before closing is a short position. Is hard to deliver dividend if short on closing. Well, that's true. That's true. Do you want us not to notice that the SEC protects the criminals? Do you work for CNN? Through these private communications, defendants intended to drive interest with these investors in the merger and in buying or retaining Torchlight stock, without publicly disclosing their plan or belief that a short squeeze would occur. Hey, DYCK head, if they went out and hyped the stock saying they thought a short squeeze, they disclosed, we have a plan or belief that a short squeeze would occur, you'd be jailing them. You're remarkable. Remarkable. As another example, on May 13th, Palicaris participated in a virtual meeting with a group of Italian shareholders that he believed held a significant number of shares of Torchlight stock. During that meeting, Palicaris described the plan to cause a short squeeze on several occasions. I will point out to everybody listening, it is attorney disappropriate who is saying that this was a plan. It may have been a strategy, but they didn't control the results. The plan to cause a short squeeze. That's the attorney's words. I see no evidence of it in his so-called facts. So this is what Palicaris said, apparently. And there is one more element to add here, which is let's call it the X factor. If you notice, the Torchlight stock is massively shorted because the SEC protects its valued criminal clients. This deal is set up not to give a cash dividend at closing. Okay? Because a cash dividend, the criminals would just pay out. It would be a business expense. So it sounds like attorney dismember. You are trying to protect the criminals, and your argument is they should have paid out cash to help my guys out. So in order for the short positions to cover, they have to have the stock on hand because the dividend will be paid out as a preferred share, not cash. That's fine. That's legal. As a result, there is no physical way for the shorts to cover the stock when the time is to close. And we believe there will be a potential jump toward the close. It's called a short squeeze. What is wrong with this? They did a short, I don't know what to call it. They did an ongoing depressing of the stock price, criminally, colluding, spoofing, manipulating the price, crossing, failing to locate, failing to borrow, failing to deliver, failing to receive. And you don't care about that. In addition, Palicaris and Brda use social media. Oh my gosh. They're progressive. They use social media because the SEC wasn't listening to them, because broker-dealers were non-responsive, because prime brokers were non-responsive, because FINRA is captured, because Adina Friedman runs a joke of an office. So they turn to their investors on social media? Come on. What kind of country do we live in now? To tout the preferred dividend in an indirect manner. Touting, my dear attorney misdirected, touting is a very direct form of selling something. You don't tout in an indirect manner. And of course, it was in furtherance of their market manipulation scheme. For instance, June 7, 21, 1 week before Torchlight announced the dividend record date, Brda posted on Torchlight's Twitter account a video discussing short squeezes in the context of other stocks. After viewing the tweet, Palicaris advised caution, quote, "I don't think you should be sharing posts on the short squeeze yet, just my 2 cents. Doesn't sound like they were colluding to cause a short squeeze. Once it happens, it's okay, as it's a fact. But before you are putting yourself at risk for potentially speculative content." attorney dissembler. Their discussion proves that it's just speculation whether or not the stock will squeeze. On June 13th, 2021, the day before Torchlight announced its preferred dividend, Palicaris tweeted a graphic of shorts in flames. Kicking off a series of tweets designed to promote the short squeeze theory and encourage investors to purchase common stock. So Palicaris wrote on June 13, to commemorate the Torch MMAT merger, we are thinking of launching a one-time limited edition in shorts in flames this summer. If we get 500 likes on this post, we may actually do it. Palicaris testified during the SEC investigation that his tweet had nothing to do with the concept of a short squeeze, but the timing, circumstances, and the content of his tweet imply that he intended to tout the preferred dividend would set the Torchlight's shorts on fire by triggering a short squeeze. That's all sorts of manner of magical, manipulated thinking on your part. Just because you think it doesn't mean it's what George was thinking. The reaction of his Twitter followers also belies his testimony. Several comments. So here, Your Honor, we're just randomly selecting some comments on a social media which we've just disparaged. And we're not sending all of them to you, just the ones that help attorney disparagement's case. You should set the price of the shorts, the price of Torch at the end of the short squeeze. This is class. Burn the shorts. We definitely get the reference. Shorts are getting burner. Need a solid PR this money. Flame those shorties. This week will be epic. Torch the shorts. Palicaris knew or had notice of these comments. For example, he later reports in his tweet, it also demonstrates he was closely monitoring his engagement on Twitter. But he did nothing to disabuse the connection his followers on social media were drawing between his tweet and the short squeeze. This is a shotgun approach. Just shoot every piece of crap against the wall and see what sticks. Oh God, it just doesn't end. Defendants made false and misleading statements and omissions regarding the value of the preferred dividend in furtherance of the fraudulent scheme. As part of their scheme, defendants also made false and misleading statements and omissions in public filings and public statements to investors about the preferred dividend. These misstatements and omissions created false impressions about the value of the preferred dividend and the likelihood that holders of the preferred dividend would receive a distribution of the net proceeds from the sale of Torchlight's oil and gas assets. As further described in my misleading claim below, defendants made these statements knowingly or were severe in their recklessness to induce investors to buy or hold Torchlight. Brda made false and misleading statements and omissions in Torchlight's proxy filings and 8K filings about ongoing, quote, commercially reasonable efforts, unquote, to sell Torchlight's oil and gas assets and plans to distribute, quote, net proceeds to the holders of the preferred dividend. In Torchlight's public filings leading up to the merger, Brda bolstered the potential value of the preferred dividend through false and misleading statements and omissions. Specifically, Brda misrepresented in Torchlight's public filings that Torchlight would make, quote, commercially reasonable efforts, unquote. He just always repeats the same thing to fill it out. To sell its oil and gas assets and distribute the net proceeds to holders of the preferred dividend within 6 months of the merger closing. Torchlight claimed that if the efforts to sell were unsuccessful 6 months after the merger date, it would then consider spinning off the assets. In reality, there were no prospects for selling Torchlight's oil and gas assets within 6 months of the merger closing. And Brda, well, okay. That's your opinion. That's also the advantage of 2020 hindsight. It's nothing fraudulent. His misrepresentations and omissions created a false impression about the likelihood that preferred dividend holders would receive a return on their investments in the form of a distribution of net proceeds from the sale of its oil and gas assets. That's your misstatement of facts. That is a complete misrepresentation, attorney dissembler. You might as well, I don't know, you should maybe go into fiction. Brda, through Torchlight, made this representation in Torchlight's Form 8K, dated 23 September 20, announcing the merger, stating that the merged company of Torcha and Medlite would, quote, use its commercially He quotes it again. Tell Vonnegut he's fired. This doesn't feel heavy enough. Add a few more pages, would you? Brda said, quote, use its reasonable efforts to cause Torchlight oil and gas assets to be sold, within 6 months of the initial merger date. Reasonable efforts. Did you actually go to law school? You one of those ones that studied on your own. Reasonable efforts. Torchlight legacy shareholders will be entitled to a special dividend distribution of any values attributable to the sale of Torchlight's existing oil and gas business, net of certain debt and holdbacks. Brda repeated a similar version of these false and misleading statements in several of Torchlight's subsequent press releases. He lists them. Each of these filings stated Torchlight would distribute, quote, net proceeds to shareholders who received the preferred dividend. A distribution of net proceeds could only happen after Meta 2 made efforts and the successor after the merger, Nuco, made efforts and succeeded in selling the oil and gas assets within 6 months of the merger closing. There was nothing in Brda's statement that said if he didn't sell them in 6 months, he'd stop trying. Attorney dissembler. I'm leaving the biggest one off, attorney dishonest. As another example, in the press release announcing that Torchlight and Meta 1 signed a definitive merger agreement, 8K 2020 December, quote, following the reverse split and prior to the effective time, Torchlight will declare and issue a dividend on a 1-for-1 basis of shares of preferred stock to the holders of its common stock. Following the effective time, the holders of preferred stock will be entitled to a dividend based on the net proceeds of the sale of any assets that are used or held for use in Torchlight's oil and gas exploration business, subject to certain holdbacks, unquote. In certain Torchlight proxy statements, which Brda approved, Torchlight repeated the claim that it would, God, just quote the same thing over and over again. It would, quote, make commercially reasonable efforts to sell the oil and gas assets. The proxy statements also contain statements about the distribution from the sale of the assets, as well as the statements emphasizing the preferred dividend would not be registered or traded on any exchange. That's all not only legal, that's full disclosure. Attorney dishonest? Have you heard of Reg FD? And then Attorney Dissembler goes on to say, consistent with Brda's plan to cause a short squeeze and lead investors to believe a short squeeze would occur. So which is it? Which is it, Attorney Dissembler? Is it that he's going to cause a short squeeze? Or he's misleading investors into believing a short squeeze will occur? Does he have the power or does he not? I'll tell you what, he does not have the power that the SEC's protected criminal class does. By way of example, Torchlight's definitive proxy statement containing the false and misleading statements about commercially reasonable efforts to sell the company's oil and gas and a distribution that, quote unquote, may be made available. Exactly. They said it may be available. I guess you grew up in that group of millennials or Generation X that everybody got an A plus. Preferred dividend. This is proxy statement. This is what it said. The arrangement agreement provides that Torchlight and the combined company will use commercially reasonable efforts to sell the oil and gas assets, within 6 months of the merger closing, period. Reasonable efforts. Torchlight stockholders, as of record, as of the Series A preferred record date, will receive a dividend on a 1-for-1 basis of shares of Series A preferred stock. Holders of shares of Series A preferred stock may receive asset sale dividends from any asset sale transactions consummated within 6 months of the merger closing, and may also receive a spin-off dividend of any remaining assets that have not been sold in an asset sale transaction within 6 months. So this Attorney Dissembler is trying to take a very clear sentence which says, if we sell assets within 6 months, we'll distribute cash. If we don't, we'll distribute the asset. And we're going to use reasonable efforts. And Attorney Dissembler is trying to turn this into some kind of violation. Do you have no sense of decency, sir, at long last? These statements were made repeatedly in Torchlight's proxy materials, as they should be. May, reasonable efforts, we're going to distribute cash if we sell anything. Afterward, we'll just distribute the remaining asset. Only a lunkhead couldn't understand that. I get it. Attorney Ginger Rogers is dancing backwards, and you're driving the boat, Attorney Dissembler. But could you do it in fewer pages? Not only is this a weak-ass claim, it is a long-ass claim, and I'm tired of it. These statements were made repeatedly in the proxy materials. He repeats everything. The company touted its, quote, commercially reasonable efforts to sell all of its oil and gas assets a half a dozen times. Oh, you want them not to? God. In its May 7, 21 definitive proxy statement, and with similar frequency in preliminary proxy. So what's your point? Attorney disillusional, attorney deceptive. These statements and representations made by Brda in Torchlight's public filings, proxy statements, and press releases were false and misleading at the time they were made. As Brda knew or was reckless in not knowing, Torchlight had no prospects to sell its oil and gas assets and had taken no actions to lay the groundwork for sale when these statements were made. You are a Van Dyke. So, on the one hand, there were no prospects to sell. On the other hand, he had taken no action. But he did say, if he didn't sell anything in 6 months, he planned to distribute the whole asset. Attorney dissembler, you really should go back to Dewey, Cheatham, and Howe. Brda also knew that Torchlight had unsuccessfully tried to sell its largest oil and gas asset for years. Yeah, during the years that the SEC's protected criminal class destroyed the stock price so they couldn't drill wells. This isn't rocket science. You have stock manipulators protected by the SEC, and then you have investors and CEOs trying to survive. It's not rocket science. Due to the size and unproven state of Torchlight's oil and gas assets, only a small number of companies that's your opinion, were possible candidates to purchase Torchlight's assets. And Torchlight's records do not reflect any prospects or discussions with any candidates in 2020 or 2021. They didn't really have anything to sell. Just because it was 2020 and 2021, the results were going to be different than they had in the years past. They had to drill wells. They had no money because of the SEC's protected criminal class made it so. Likewise, during the SEC's investigation, neither Torchlight nor Brda could identify any specific prospects that the company had discussion. Fine. Maybe they wanted to hang on to the asset and build it out, which is occurring right now. And it's perfectly fine. Without any identified buyers or ongoing negotiations, Brda knew or was severely reckless in not knowing that a sale of Torchlight's assets within 6 months of the merger was not possible. In your opinion, you don't know. There might have been discussions before. But he said after 6 months, he'll distribute the remaining assets. What do you want for nothing? Rubber biscuits? As Brda knew or was severely reckless in not knowing, it would take at least a year. He didn't know that, if not longer, simply to complete the due diligence that a specialized buyer would undertake before completing a sale of Torchlight's assets. No. And besides, I haven't seen the document, but what if they signed a letter of intent? That might qualify to extend that 6 months. Who knows? You're the vaunted securities attorney, I guess. Maybe you should stick with family court where you can get into these endless circular arguments and pedantic conclusions. In addition, Brda knowingly or severely recklessly omitted material facts and informations that were necessary in order to make his statements in Torchlight's public filings referenced in paragraphs 68 through 74 not misleading. Among other things, Brda failed to disclose that at the time of his above referenced statements, Torchlight had no, had no specific prospects or candidates to buy its largest oil and gas assets, that Torchlight had unsuccessfully tried to sell these assets for years. Circular arguments, pedantic conclusions, that Torchlight had no plans in place. Oh God, the same. To use commercially reasonable efforts to complete the sale of its assets within 6 months of the sale. He didn't say the sale of its assets. Obviously, they were trying, but he said any remaining assets would be distributed. You're the one misconstruing the words. To complete, Brda also knowingly or laid the foundation for a spinoff of Torchlight's oil and gas assets into a new entity as early as December 2020. So what? Mere days after the definitive agreement for the merger between Torchlight and Meta One signed. In particular, beginning in December 2020, Brda circulated to Torchlight's chairman and other insiders presentations outlining capital formation plans for a spin-off entity. So what? He did not publicly disclose these plans. It's not his responsibility. It's not his responsibility. Hey Hitler, we're landing at Normandy. Not that fake landing that we had Patton construct up the coast. I mean, come on. It's not, when CEOs are making strategy and boards making strategy, they don't disclose everything along the way. That way, your SEC's protected criminal class doesn't have a head start to find out a way to figure out how to continue to flood the market with non-existent shares, violating securities laws, which you don't care about. Additionally, Brda knowingly or severely recklessly failed to disclose that in January 21, he caused Torchlight to begin secretly, how much are you making? Paying $20,000 a month to individuals who would form the initial management team of the spin-off equity. What's wrong with that? Putting a team together. Starting to have it coalesce and work together. Hit the ground running. Ooh, it was in secret. Ooh. To conceal his plans, Brda caused Torchlight to make these monthly payments through an intermediary who received consulting fees for doing no actual work. He further caused Torchlight to keep inadequate books and records, maintain insufficient controls, to document why Torchlight was making these payments. Brda did not publicly disclose these payments or his fully formed spin-off plans before the merger closed. You got me there. It's a completely idiotic argument. Why would he let the SEC's protected criminal class know his plans? Number one. Number two, he had no obligation to disclose that until the spinoff occurred, maybe, if he's in charge or not in charge. And it's in the discretion that the companies don't disclose everybody they hire or employ. You said in the beginning of your document that Torchlight only had 3 or 4 or 5 employees. No wonder he has to go out and hire people. I think, the more I think about it, family court, where you can go around and around and around with endless, senseless arguments. I think that'd be right up your alley. By August 21, just 6 weeks after the merger closed, Brda sent the post-merger Meta 2 board a fully formed plan. All right, so he sent it to abandon all of its so-called efforts to sell the assets and instead to spin off the assets. Why could that be, attorney? Why would that be, attorney disbarred? It could be because John Brda, after 10 years of working with Rich Masterson, who delineated the Delaware Basin, and John Brda, who had drilled some wells, and John Brda, who had 3D seismic, and John Brda, who knew the extent of the Oro Grande field, and more than you, understands oil and gas, decided it was best for everyone to develop the assets away from Wall Street, away from the SEC's protected criminal class. So he sent a fully formed plan to abandon all of its so-called efforts to sell the assets and instead to spin off the assets into the spin-off entity, which had the same name as the spin-off entity that Brda identified in his presentation to Torchlight's board back in 2020, with a specific management team that Brda and Torchlight had been paying clandestinely through an intermediary since January 21. Oh, for 6 months. Hush your mouth. For 6 months? Clandestinely? Ooh, you got him. Hey, attorney dissembler, you got him, boy. You got him, man. You did some real digging there, didn't you? Ad hoc vice. Consistent with Brda's recommendation, August 17, 21, less than 60 days after the merger closed, Meta 2's vote voted to discontinue any so-called effort to sell assets and instead drill wells required to maintain the leases, and with a goal of spinning off the assets into a separate company as soon as possible. Pow. Attorney dis. Attorney disrespect. You drill wells to maintain leases. That's one reason. You also drill wells for the science you get. And what else do you drill them for? Oh, prove up the value. So no one believes there's anything there. You drill a dozen wells, 20 wells, all of a sudden the value jumps from 0 to, I don't know, $5 a share. Is it worth that? If he didn't do that, you'd be accusing him of violating his obligation to his shareholders. I think family court. Thus, Brda knew that no commercially would be undertaken to sell the assets, that the assets would not be sold within 6 months, and that no distribution from such a sale would occur. He knowingly, severely, recklessly made false and misleading statements. That's not true. You're putting that spin on it, attorney dissembler. Okay, now Palikaris made false statements. May 31, 21, in the Italian investor call. Palikaris believed that investors on the call held a significant number of shares in Torchlight. Stated purpose of the call: solicit proxy votes in favor of the merger. What's wrong with that? Encourage investors to hold common stock post-merger. What's wrong with that? Discussed in paragraphs below, made false statements. All right. First, Palikaris claimed that Torchlight was speaking to the, quote, right potential buyers. This is repetitive. I think family court. You be repetitive all you want. He said, she said. I think a lawyer of your caliber deserves family court. And that the buyers were, quote, top tier. However, as Palikaris knew or was severely reckless in not knowing, Torchlight had not identified any potential buyers. In fact, Palikaris admitted in sworn testimony he had no knowledge of buyers, but they had been trying and they knew the value. Attorney dissembler. Second, Palikaris claimed that based on the analysis, the value of the preferred dividend could be between $1 and $20 a share. Completely reasonable. In fact, I'll go further, attorney disinterested. Torchlight stock, absent the fraudulent manipulation, illegal coordination, and failure to settle from the SEC's protected criminal class, Torchlight stock should have been $20 a share. It's the same asset. All of your arguments are circular because the protected criminal class by the SEC sold the stock down in illegal, massive ways. Any attempt to get the price back to fair valuation is manipulation on the part of the company. I really think family court, because you can go around endlessly. She did this, he did that. It's perfect for you. And your pedantic arguments. As Palikaris knew or was severely reckless in not knowing, the $1 to $20 per share range that he identified was wholly unsupported. Oh. I don't want to spend a lot of time finding this, but if I find it, I'm going to read it to you. Okay, from Noble Capital Markets, dated October 23, 2018. Target price for Torchlight, $1.45. There's some foundation for the dollar part of his statement. Now I got to get, there's one more here. Shoot. Okay. All right, go back. Okay, one more. Roth Capital, dated June 18, 2018. Torchlight buy. Let's see what their target is. $1.75. I know the shares probably changed a bit, but the asset didn't. So you say here, wholly unsupported. No, your charges are unsupported, attorney dissembler. Likewise, there was no analysis supporting his statement. I just showed you two from a while ago. Indeed, by the time he made this statement, he had reviewed the investment bank's third-party asset valuation, which implied an estimated value of less than $1 a share. Since you don't attach that, I don't see it, but I think there could be an argument at the time for values less than $1. But that's not necessarily, you don't provide that evidence. But that's also one analyst. Palikaris knew the well results. He knew the seismic. And he also, well, probably more Brda. But I don't agree with your blanket statement at all. By at least June 11, 21, a partial audio recording of the Italian investor call had been posted, which included Palikaris' false and misleading statements. It quickly became a topic of discussion. A common refrain on the social media, which I just disparaged, but now I rely on, was that the company's post-merger CEO estimated that the preferred dividend would be worth $20 a share. Well, how do you know it wouldn't have been if you had let it trade? How do you know on those 2 days? How do you know? Palikaris and Brda were aware of the discussions in social media. After the merger, Meta's twos business development emailed Palikaris and other members an investor complaint citing the $1 to $20 dividend range. The dividend was never going to be worth more than $1, it said. The math was not difficult prior to the merger. Value of oil and gas assets, number of pre-existing Torchlight shares. Palikaris knew that it never had any basis in fact. I don't agree with you. The criminals that you protect on the other side probably can make this argument, but none of us know what the reserves are worth. I would argue, though, that the value, because they need to drill wells and have only drilled 15 or 16, it's probably not, to a lawyer's eyes, and your criminals drove it down under $3. Nah, I don't believe this. You don't state who the investor was. Could have been one of the SEC's protected investor criminal class. I don't know. Defendants' false and misleading statements gave investors false impression Torchlight had made progress to selling assets. Quickly monetized. This false impression incentivized investors to acquire or hold Torchlight common stock through the record date to be eligible to receive the preferred dividend. You're misreading your audience. That I talk to investors all the time. There's almost no one who wanted to hold the preferred dividend. They all were in it for the 2 days trading that your employers U3 halt, probably illegal, stopped. The stock traded as high as $2,400 a share in a filed lawsuit. $2,400 a share on the Friday. So all your value made up nonsense is just that, nonsense. Torchlight legacy shareholders who believed defendants' misrepresentations about the dividend value were incentivized not to sell before the record date. Maybe, maybe not. Who knows what each investor was thinking, and thus missed the opportunity to sell when Torchlight stock price increased leading up to the merger. Wait a minute. You're saying that Palikaris and Brda connived to artificially inflate the price of the stock and they broke the law by planning on an ATM, but you're saying that investors missed the chance to get out of this same dastardly act? I think family court. You'd probably understand the issues better. In turn, this false impression furthered defendant's scheme to manipulate the market by artificially inflating the value of Torchlight stock. Defendants succeeded in manipulating the price of Torchlight stock. As a result of their fraudulent scheme and through the use of false and misleading statements and omissions, defendants artificially inflated the price of Torchlight stock in the days and weeks leading up to the merger closing in June 2021. On June 14, 2021, just a day after Palikaris made his Shorts and Flames tweet, mentioned in paragraph 64 above, Torchlight issued a press release announcing the preferred dividend record date as of June 24, 21. That same time, Palikaris issued a tweet linking the press release stating, "Nice release by Torchlight. A dividend record date is 6/24. 10-day notice required. There is a T+2 rule, so the last time to be in is Tuesday, 6/22, end of the day." Posts and contents from other users on social media on or around June 14, 22, 21 show investors following news about Torchlight's and or Meta One understood Palikaris' tweet to mean that the key to obtaining the benefits of the short squeeze and the preferred dividend, which Palikaris had led investors to believe was worth $1 to $20 a share, was to buy or hold Torchlight stock through June 22, 21, T+2. As defendants intended, users on Twitter, StockTwits, YouTube, Reddit, and other social media platforms discussed the merger, the preferred dividend, and the short squeeze in the days leading up to the record date. On June 14, 21, Brda sends Palikaris an image of an online campaign promoting short squeeze theory using a hashtag #TorchDay. What's wrong with that? What's wrong with that? Are you saying the only place investors can go is with the plunderers, with the big pools of money, so they can keep funneling your paydays to you? Attorney disarray. Using the hashtag #TorchDay. An anonymous user, we better bring that into the case, created a graphic that conveyed the precise message the defendants privately hope to spread. Oh yeah, it's anonymous. But only you can glean it. Post and educate people about our short squeeze, #TorchDay. Post and educate people about our dividend, ranging from $1 to $20, deadline 6/22. That same dividend, attorney dissemble, traded on December 9, 22 for $2,400, according to footnote number 7 in a filing in Florida for intercoastal waterways. The graphic went on to explain, Torchlight is a heavily shorted stock, which is true. Nothing that has happened since then disproves that statement. And due to the fact that a preferred dividend is being granted to stockholders, shorts have to cover. Absolutely. Except the SEC protects its criminal class who enrich Goldman Sachs and other prime broker dealers. 80% of Goldman Sachs's revenue comes from this. 75% is profit. The graphic went on to explain Torchlight is heavily shorted. Shorts have to cover, which can lead to a short squeeze. Can lead to a short squeeze of the stock. The #TorchDay graphic also explicitly referenced Palikaris shorts inflamed tweet. I'm going to skip the T+2 footnote. Social media users posted the hashtag and versions of the graphic dozens of times over a few days around June 14 through 16, 21. And users on many other social media platforms picked up on the basic gist. And you got it too, didn't you, Attorney Dissemble? To promote purchasing Torchlight common stock to benefit from the supposed short squeeze by June 22, using other hashtags, subreddits, iterations. Trading volume of Torchlight stock dramatically surged as the merger approached. In May 21, the average trading volume was 5 million shares a day. Attorney Dimwit, do you think this could be because shorts were covering? Oh no, it was the manipulation by Brda and Palacaros. I got you. That wasn't retail. Retail wasn't buying 5 million a day. But between the announcement, the average trading exceeded 80 million shares a day. Putting lie to your claim that the stock wouldn't go up, that there wasn't a squeeze, that there weren't shorts. Come on. Likewise, following the announcement of the record date on June 14, the price of Torchlight stock surged. The price at closing jumped from $3.58 per share on June 14th to $5.07 and then $5.99, peaked at $10.88 for an increase of over 200%. Torchlight stock price artificially increased as a result of defendant's schemer. You know what, Attorney Disco there and Disco there? I really don't know where your brain is. Another equally plausible reason the stock price went up is all those undelivered, non-located, non-borrowed, non-received, non-settled shares were being closed. However, evidence available at this time is inconclusive as to whether or to what extent the trading volume was attributable to short sellers covering their positions versus defrauded investors purchasing Torchlight stock to burn the shorts or obtain a preferred dividend they believed was worth $1 to $20. Verdict's still out on that. Regardless, at the time that Torchlight stock price was surging in June 21, Brda and Palacaros believed that a short squeeze was driving the surge. For example, as further discussed below, on June 18, 21, Torchlight stock price began to increase. Brda told Palacaros they needed to, quote, take advantage of the squeeze, unquote. Sounds like AMC, GME, and many other companies, which they did through an at-the-market offering that they had discussed in September 20. They were ready for it. Look how many companies have at-the-market offerings already in the books in case the stock goes up. Why? Because they don't want to rely on the liars who are your clients through the SEC. Through their deceptive marketing and promotion, defendants led retail and other investors to believe that a short squeeze would occur and drive the surge in Torchlight stock price. Look up the Intercoastal Waterways filing. I think it's page 8, footnote 7. There were closed, paid-for trades, settled trades on the Friday, the 9th, I believe, $2,400 a share. The aim of the defendant's scheme was to manipulate the market by artificially increasing Torchlight stock price. Defendants achieved the aim when Torchlight stock price suddenly temporarily surged as a result of the defendant's plan and their intent to manipulate the price of Torchlight stock. As discussed below, they achieved the other aim. Brda deployed an at-the-market offering to capitalize on the fraudulent scheme. Upon successfully manipulating the price of Torchlight stock, I don't see any evidence of that, Brda set in motion the next phase of the scheme, ATM offering. His plan, which was not disclosed, sought to capitalize on what he knew. Before the ATM offering, Brda sought formal agreement to use the funds towards drilling oil wells. In the beginning of this, Attorney Dissembler, you said Brda had been negligent in not increasing the value of shareholders' price, in not increasing the asset. I'm paraphrasing, of course, and that Torchlight was in dire straits financially. Are you saying this is not in the best interest of shareholders to raise money? So you're saying that he manipulated and caused a short squeeze, and then he stopped the short squeeze by having an ATM offering out there to use to drill wells, which is, yes, to hold the leases, but it's also to prove up the property. So you're also saying he stopped the short squeeze and therefore hurt investors? I really think family court, this kind of back and forth with brain dead clients, it's right up your alley. He executed the offering for oil wells. He wrote, Brda did, to Palacaros, we have the ATM, which will be in play by Thursday morning, up to $100 million. Raising money prior to the dividend record date, in my opinion, is the best way to get maximum money at the best price. That's what a CEO's job is. It's absolutely incredible to me. Absolutely incredible. I believe I can get my board to approve if Meta would agree to lend a decent portion of the raise to Torchlight, say 20% of the amount raised. Otherwise, we have no inclination to raise capital now, as it only dilutes our oil and gas assets further. The ducks are quacking, time to feed them. That is a completely attorney dissembler. That is completely rational, fair-minded, and appropriate. I don't know. Maybe break up with the girlfriend or the wife. You're not thinking clearly. Although Palacaros knew from the outset of negotiations about Brda's plan to use an ATM offering to capitalize on this scheme to manipulate the price, you keep repeating it. The more you repeat it, the more it upsets me, because the more you say it does not make it true. There was no scheme to manipulate the price of Torchlight stock. The only scheme to manipulate the price of Torchlight stock comes from the SEC's protected criminal class to drive it down, keep it down, hire attorneys who have no honesty, no backbone, and no compunction to lie and mislead to keep the price down. Although Palacaros knew from the outset of negotiations about Brda's plans, Brda waited to make this request to use funds from ATM offering to pay Torchlight's drilling until June 16, 2021, less than 10 days before. Okay, he didn't know there was going to be a short squeeze. He didn't know this volume was going to come in, and as it did, he sought to take advantage of it. Jack be nimble, Jack, be quick. Don't hire an attorney who is a dimwit. At any point in time, Brda had leverage over Palacaris and Meta One, who stood to reap the benefit of the ATM offering for Mega 2's post. So they recommended the board that they take the deal. So Palacaris wrote, all Meta strongly recommend we take as much money as we can ahead of the closing, unquote. Turned out to be the right move. The stock went down. If they didn't take it, the SEC's protected criminal class would have. So easy, attorney dissembler, to put your rather dim legal mind to work with 2020 hindsight. So easy. And while the ATM offering would be dilutive to Torchlight Common before ex-dividend date, however, it also takes advantage of the potential best pricing due to any short covering effect prior to the date. Emphasis added. Okay, so they're guessing just like every investor was guessing. Could a short squeeze come? And they didn't know for sure that all that buying was going to come in. And by the way, that's not Twitter. That's not Reddit. That's institutional. 80 million shares. That's short covering. That is the SEC's protected criminal class coming in to buy. And you admit you don't know who it was. But it doesn't stop you, attorney dissembler, from making statements that you count as fact. This is going to be kicked out so fast, it's going to make your head disassemble. Meta One did not formally agree to Brda's demands. Nonetheless, Torchlight ultimately did vote to proceed with the ATM. They did fund the oil and gas, consistent with Brda's original plan and scheme. You're a nightmare. You are a nightmare. Looks like Brda took advantage of the market, which for once in a long while, since the SEC's protected criminal class got involved, for once in a long while, gave him some surcease so that he could go out and get some money. And guess what? He only took 20% of it. More importantly, Brda and Torchlight went forward with the offering as defendants had planned. You just said that he wrote at the last minute, otherwise he was going to stop away. Family court. Attorney Patrick Dis-Bennett. Family court. Okay, the ATM offering starting on June 18, just days before the June 14 announcement of the record date. Well, that doesn't sound, June 18th sounds after June 14. Oh, that's what I said before. He wrote it, I'm wrong. It says, Brda caused Torchlight to commence the offering starting on June 18, just days after the June 14 announcement of the record date. Brda intended the ATM offering to capitalize on defendants' price manipulation. There's no evidence that they manipulated the price. None. Just keep repeating it, though. On June 18, 21, after the ATM offering had commenced, Brda wrote Palacaris, "We need to be selling more than we are. The shorts always push down at the end of the day. We have 2 days to take advantage of the squeeze. Today should have been 5 million shares at 6. Sounds like he knows what he's talking about. Sounds like Brda is husbanding the value of the raise and his asset for his shareholders. He doesn't dilute the shares as much as the SEC's protected criminal class would like. Palacaris knew about and agreed with Brda's plan to use the ATM offering to capitalize on their market manipulation effort. Just keep repeating it over and over again. I know if you keep saying it, I bet if you could say the same charge 40 times in this, maybe 50, I'll start believing you. But it hasn't worked yet. There may be at one point in this complaint, if you state it one more time without supporting evidence, I'll just take it in blind faith. Attorney disbarred. On June 16, as Torchlight's stock price continued to rise following the announcement of the record date, Palacaris wrote Brda to express his agreement with taking advantage of the inflated value of Torchlight stock. Up to the moon, we are happy to take 100 to 200 million at a 20% premium to the market and a minimum of $7, whichever is largest. Then on June 18, in response to Brda's above-cited message, Palacaris wrote, "Go ahead to 575, 5 million shares, fill her up." These are decisions being made with people who are working to create value, unlike you, attorney disinterested. They actually are trying to build two companies. All you are there is to support criminals. I frankly am astonished by the SEC. Astonished. The criminality is out there to see. It's in the fact that they didn't settle the trades, making every prediction that Palacaris and Brda made correct. Even when you look backwards, you get it wrong. Attorney disassociated from the facts. Ultimately, Torchlight, through an investment bank, conducted the ATM offering over a 5-day period between June 18th and June 24. In the middle of that offering period, on June 21 through Torchlight stock price reached a record high of $10.88 per share. I don't think that was the record high of the high stock, but I could be wrong. I think I paid more years before, but I could be wrong. And closed at $9.92. Overall, Torchlight sold 16.2 million shares during the ATM offering at an average price of $8.50 a share. Over 95% of the volume was sold prior to the T+2 date. In total, Torchlight raised $137.5 million through the offering. Remember, Torchlight now is Meta Materials. Just remember that. Torchlight stock price fell dramatically. I mean, maybe not technically on that day, but it's the agreements in place. Fell dramatically after the T+2 date with the help of the SEC's protected criminal class and Torchlight's completion of the ATM. On June 22, T+2, the stock closed at $7 per share. By the 25th, after the offering, the stock dropped to $4.95. The following Monday, the 28th, after Torchlight announced a 2-for-1 reverse stock split, which helps the SEC's protected criminal class, it allows them to reduce the maintenance requirement on their short position by half so they can take money out without a closing transaction and without paying taxes. This funnels money into the river of money, which Patrick called it. Burns called it. A river of money. That's how your salary's being paid. Attorney disbarred. Torchlight announced a 2-for-1 reverse stock split. Completion of its merger. The company's news ticker, MMAT, closed at $3.98. Less than half its prior day closing price. Investors who purchased or held Torchlight Common during the fraudulent scheme suffered pecuniary harm. No, they suffered harm because of the SEC's protected criminal class. Their actions were to sell, it sounds like, tens of millions of shares into existence which did not exist. They did not locate, they did not borrow, they did not deliver, the other side did not receive. That's where the manipulation came from, attorney dissembler. Brda profited off his fraudulent scheme and false and misleading statements to investors. On June 24, immediately after the offering, and one day before the merger closed, Brda used Torchlight's compensation committee to award him a $1.5 million bonus. He presented the committee with a top 10 plus 2 reasons to pay bonuses to John Brda. I think he deserved it. Who are you, attorney underpaid dissembler? You're probably making $1.5 million off of this lawsuit. Ad pro hoc vice, application pending. I bet before it's approved, you'll have removed this completely frivolous lawsuit, which touted his achievements in conceiving and executing the Torchlight Meta merger. Damn straight. Damn straight. At least he was trying to create value, unlike the criminals the SEC protects. He specifically pointed out that he, quote, managed the entire merger process with Meta, leading to a market increase from 30 million to 1.4 billion. Damn straight. Look at Elon Musk. Of course, the Biden judge doesn't want to do it, but the Texas judge might. But Elon Musk got paid bonus. Look at all your paymasters. Look at Citadel. Look at Stevie Cohen. Look at Black. Look at all the plunderers. Not only are their trades 60% short-term taxes, if they can get at arm's length people to do this on their behalf, they don't pay taxes on their probably 60% of the gains because they front it. Then they juice their returns by the fraudulent manipulation in the prices, for example, of Torchlight. They lock it down. They get the reverse split. They get you through the SEC to defend them. And with that stolen money, they get bonuses. Who are you to judge the bonus? It's how you're getting paid. If they didn't take that money and agglomerate it in the hands of just 6 or 7 white boys, how would you be getting paid? I really think, the more I think about it, family court. Traffic court might be interesting. It has the redundancy that you're looking for, the repetitiveness. Maybe traffic court, DUIs and such. He also wrote that he conceived the timing of the shareholder meeting with Windows to raise additional equity and filing of a shelf for 250 of 130. He handled all investor calls and fund calls during the process. He requested a bonus of $1.5 million. I'm not quick with my arithmetic, but that sounds like 1% of the high market cap. What do your paymasters at Goldman Sachs get? Huh? What did Gary Gensler make at Goldman Sachs? Who are you to judge? Go get a job where you actually have to work to make a living, where you actually have to do something to create value. Stop being a criticizer. But I have a suspicion you're being paid a lot for this drivel. Pro hoc vice. Meta 2 paid Brda 1.5 bonus in 2 increments. Brda received his 1.5 million bonus as a result of the funds he raised through his market manipulation scheme and his false and misleading statements and omissions. What about your false statements and omissions? Do you want me just to believe that you're stupid? You're doing your best? Who are you protecting? Really, who are you protecting? Indeed, to his request to the compensation committee, Brda attached a spreadsheet reflecting Torchlight's remaining obligations, which makes clear that the company would not have sufficient funds to pay a 1.5 million bonus or its existing obligations, but for the proceeds of the ATM. So in other words, he wouldn't have gotten paid anything if the at-the-market offering hadn't worked. Okay. All right, claims for relief. Okay, first claim. Everything I've read to you in these 2 things. By the way, I'm going to take a minute here. I think I already said it on this video, but everything I say is in my opinion. It's in my judgment. It's on the basis of my belief and knowledge, at least what I think I know. It's all said as an editorial. It's all said as a educational effort. It is my point of view on this ridiculous filing. But I'm not a lawyer, so if you want to base your thoughts about this case or these lawyers on professional advice, speak to an attorney or research them. But this is an editorial effort on my part. But all 3 videos. As ever, as all my videos. Okay. Between at least June 2020 and June 25, 21, defendants planned and perpetuated a scheme to manipulate the market by artificially increasing the price of Torchlight stock on a temporary basis, because we all know that the SEC's protected criminal class is not used to stocks going up. Not what? With their ability to sell non-existent shares into existence across a whole swarm of stocks using computers, stocks shouldn't go up. Not in Gary Gensler's markets. Stocks, these low-priced stocks, they should never go up. We know the manipulation we're putting on them. So the only way they're going up is if the CEOs do cheat. No. Attorney dissembler. It's the other way around. The cheaters are the crooks the SEC protects. It's the whole bleeding, bloody system. And when it comes down, and it will, you can be proud to know you protected the criminals. But I bet you don't make a public announcement about that, do you? You do it in secret, don't you? Defendants also knowingly or recklessly made false and misleading, all right, same crap, directly or indirectly, offers securities use of mails, so mail fraud. All right, let me just get to the defendants have violated and unless enjoined will continue to violate Section 17A of the Securities Act. Oh, you do refer to the Securities Act. Settlement. Providing in writing before you sell a share that you've borrowed it, located it, or own it. After you sold it, you might have 2 or 3 extra days to deliver it. So you know the Securities Acts. Bravo. Look it up. So they need to be enjoined or they'll continue to violate Section 17A. Then they reallege everything in the second claim. False and misleading, conduct, same, blah, blah, blah. They have violated and unless enjoined will continue to violate Section 10B. Third claim, incorporates everything. Solicited shareholder approval. What's wrong with that? Oral and written calls, acts of conduct indirectly, use of mails. By reason of the foregoing, defendants have violated and unless enjoined will continue to violate Section 14A of the Exchange Act and Rule 14A thereunder. Fourth claim, incorporate everything. Torchlight was an issuer. Violated Section 13A of the Exchange Act, Rules 12B and 20, 13A and 11. Cease and desist order, blah, 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 blah. So Meta consented to an SEC cease and desist order. Great. That's going to make it really easy for the SEC's protected criminal class to start punishing the stock price of MMAT. By engaging in the acts and conduct alleged herein, Brda aided and abetted Meta's violation. By reason of the foregoing, Brda directly and indirectly aided and abetted, and unless enjoined will continue to aid and abet, and or should be restrained from further aiding and abetting violations of Section 13A of the Exchange Act and Rules 12B through 20 and 13A through 11. Fifth claim for relief. The SEC realleges and incorporates all the crap above. The consultants were paid, used to funnel $20,000 per month to the spin-off equity entity management for 6 months. No contracts. For a reason of the foregoing, Brda directly or indirectly aided and abetted, and unless enjoined, will continue to aid and abet, and or should be restrained. Sections 13B, 13B, 2B, 13B, 2A, and 13B, 2B, or not to be. Prayer for relief. My prayer for relief is to never have to read crap written by Patrick Dis-Bennett, pro hoc vice application pending, or Christopher Rogers, pro hoc vice application pending, U.S. Securities and Exchange Commission, 801 Cherry Street, Suite 1900, Fort Worth, Texas. Dis-Bennett, PA, at sec.gov, DISBENNETTPA at sec.gov. Roger Creh, ROGERS chri@sec.gov. Prayer for relief. Wherefore art thou? The SEC respectfully requests this court enter a final judgment, permanently restraining and enjoining defendant Brda. They let Kurt Kramer and Seth Kramer out over and over and over and over and over again. I think I covered every one I can remember in my head. Guys, the SEC is on the side of the criminals. Completely captured. The law firms are completely captured as well, because law firms just look at money. They don't look at truth. They don't look at truth. It's just about being paid. And they'll say it's not their job to enforce the rules. So they want to permanently restrain and enjoin from violating these acts, but they don't care if the criminals do it for 2 decades. Permanently restrain and enjoin from violating these acts, permanently barring each defendant from acting or serving as an officer or director of any issuer that has a class of securities registered pursuant to Section 12 of the Exchange Act, or that is required to file reports pursuant to Section 15D. That's pretty hefty. Permanently restraining and enjoining each defendant from directly or indirectly participating in the issuance, purchase, offer, sale of any security. That's pretty hefty. Ordering defendant Brda to disgorge all ill-gotten gains received as a result of violations herein. Ordering defendant to pay civil penalties. Granting such other and further relief as this court may deem appropriate, just, equitable, and or necessary. The SEC demands a trial by jury. Attorney Patrick Bennett and Christopher Rogers. Well, let me just tell you, if you haven't learned the lesson, if you're sitting in MMTLP waiting for the system to protect you, the SEC is on the side of the criminals. So if you're waiting for a settlement to come from the SEC, may I quote the criminal on the other side of Liam Neeson's phone call in The Taken? Good luck. All right, I'm going to leave it there. This is a long call. I'm going to maybe go live, but I first might... It's another long one. I guess I'll leave this for later. I want to read out the cease and desist. Oh, it's Vanessa Countryman. Vanessa Countryman. She's the most likely person, if Gensler were kicked out, to go up there. Vanessa Countryman. Telling you guys, they're on the side of the criminals. So if you want the best chance you have of getting some sort of reward from your commitment to MMTLP, I think you got to move to the real shares. With that, I'm going to sign off. I'll see you in a little bit live. Cheers.